Missing Legal Speak of Russia and USA, Restoration of International Law as It Really Is. Statement by the author. This paper will in plain speak focus on the two allies from World War II, Russia and USA, as per the Ukraine situation facing us today. This situation is comparable to the Cuban Missile Crisis of 1962. To understand how this and other situations with the Russian Federation have come to pass in Europe, we must first start with international law and the legal speak as it really is. This paper will highlight the shared blind spot of Russia and USA in international law through their versions of legal speak, as they define them in clear history. It is my firm belief that Russians and Americans are and have been facing a $12 trillion silent war that wages against them in the background of media and global special interests. Russia and USA by institutional design are clearly unable to process the legal speak of OSCE, EU, UK, France, UN General Assembly, the Commonwealth nations and NATO. This weakness of legal speak comes from Crown customary law that is all but nearly extinct from Russian and American history books. Today I present this one-of-a-kind paper, The Missing Legal Speak of Russia and USA, Restoration of International Law as It Really Is, to give Vladimir Putin, Joe Biden, Donald J. Trump, Vasily Alexievich Nebenzia, Dmitry Polansky, Linda Thomas Greenfield and Kelly Knight Craft the opportunity to correct a flaw that not only threatens international peace and security, but threatens to destroy the Russian Federation and United States of America, thereby plunging the world into darkness once more. China falls into this legal speak pitfall as well, but because of the Olympic truce, this paper will only focus on Russia and USA at this time. It is my sincerest hope that Russia and USA will find the merit of this paper and come to terms with mistakes they have made post-1945 and continue to make today. This paper is for the entire world, but specifically it calls for Russia and USA to once again return to the victorious allies of World War II and honor the promise, never again. My name is Dave Bjorkman, a third-class Canadian of little means, and I wrote this paper in a country under Crown customary law, the UN state you know as Canada. Introduction: The Missing Legal Speak of Russia and USA, Restoration of International Law as It Really Is. This paper, The Missing Legal Speak of Russia and USA, Restoration of International Law as It Really Is, will take the world on a first-time ever journey through legal interpretation of international law through the eyes of Russia and USA, who are two of the major Permanent Security Council members of the United Nations. A comparison of that to OSCE, EU, UK, France, UN General Assembly, the Commonwealth nations and NATO will outline the distinct differences. This paper will look at history, binding world laws and present/past challenges in federalism versus regionalism of USA and Russia that is clearly at odds with legal speak in the majority of institutions listed above. An in-depth look at how USA and Russia are incapable of processing Crown customary law, bestowing international law on regions post-legal independence, and the inability of completing core institutional transfer of binding international law to new UN states, republics, parliamentary governments, or regions and protectorates whom all have been promised sovereignty and autonomy under unitary systems will be addressed. From clear analysis and historical evidence, this paper will conclude with a focus on a path forward for Russia and USA in stabilizing Ukraine and all nations for once and for all. Finally, Canada will be the concluding UN state target for an implementation of proper legal speak by Russia and USA, restoration of international law as it really is. Legal speak through the eyes of Russia and USA as it really is. Legal speak is defined by the highest law of the land, the Constitution of the Russian Federation, and the Constitution of the United States of America. That is the basis of legal speak, Lexilogos, for Russia *, and Legalese, Webster, for USA *. Both the Russia institution and the American institution are based in Latin customary law for legal speak. Civil law and common law are based out of the Roman Empire, * for Russia and USA. We see a standardized approach to developing international binding law that is missing a core understanding of Crown customary law absent in both the Russian Federation and the United States of America post-1920 USSR and 1934 United States of America. In fact, Crown customary law is completely devoid in literature post the 1945 UN Charter. It is important to introduce Russia and USA as the only UNSC permanent members whom are federal and not unitary states. Not only are Russia and USA the only UNSC P5 members who provide legal speak for regions and protectorates, they also provide a division of powers, * Russia and USA lead, but a small minority of countries in federalism. * Today, only 27 out of 193 nations have a division of powers constitutionally, and of the 27 only 7 are free from Crown customary law provided by Russian and American legal speak, *. Russia's Georgia history, from unitary states to Crown customary law as it really is. The country of Georgia is the starting point for the absence of crown customary law inside the Russian Federation. Pre-1920 Georgia was a crown monarchy operating in Europe for 1,000 years. Post-World War I Georgia attempted to join the League of Nations, and even attempted to align itself with the British Empire. The boundaries of Georgia were never cemented, and from Georgia one Joseph Stalin would rise to the ultimate authority of the Soviet Union. It is important for Russia and USA to understand that the 3 years of the Parliamentary Republic of Georgia is the only source of crown customary law in the entire former Soviet Union and current Federation of Russia's academia, encyclopedias, journals, essays and dictionaries 1917 to 2022. One country from a period of King George V and ample crown customary law is just a flicker in Russia's vast database countrywide. The Russian concept of governor being defined as anything other than a federalist division of power, to implement constitutional powers of the people of a region by that position, and in that Russian legal speak is missing from the Russian legal system entirely. Russia does not translate, communicate, or understand governor general, lieutenant governor, crown, chancellor, or any legal speak pertaining to the removal of federalism by way of a divine power of a human being found in crown customary law. Russia does not go past 1952 in successfully establishing independent nations outside of King George VI. The first European war since the fall of the Soviet Union is Georgia. It is the move by the Russian Federation to take regions out of crown customary law whereby they have lost their promised autonomy and self-determination. Russia is incapable of explaining to the vast majority of unitary states as well as the customary crown law states as to why 186 out of 193 in any legible legal speak that those nations would or could understand. USA's 13 colonies history, from unitary states to crown customary law as it really is. From the War of Independence to the conclusion of 1934's Banana Wars, we see the last example of crown customary law referenced by the United States of America over occupied Haiti. The Monroe Doctrine would once again move the United States into the constitutional republic it was designed to be. Political neutrality and limiting European colonialism remained front and center of USA diplomacy until World War II. Since Haiti 1934, USA defines crown customary law as the part of English common law that applies to criminal prosecutions. This narrow view shared in legalese, legal speak, by all Americans is in gross error to 54 out of 193 UN nations. Further, USA is unable to articulate its constant state of war against territories, regions, and other nations throughout the world today in any meaningful dialogue. This ignorance of the federal executive to comprehend crown customary law is only matched by the Russian Federation today. Like Russia, USA is incapable of defining crown customary law as does the OSCE, EU, UN General Assembly, UK, France, NATO, and the Commonwealth nations do. These entities and UNSCP5 members, as either unitary or as crown customary law practitioners themselves, do not follow Russia or USA. It is clear only Russia and USA as UNSCP5 members operate as federalists that do not give any divinity of a person to override the regional division of powers by way of constitutional law. UNSCP5 China will be examined in a later follow-up paper as per Olympic Truce, this day 2022-01-21. Along with Russia, USA defines the following. Definition of Governor General. A governor of high rank especially, one who governs a large territory, or has deputy governors under him. Definition of Lieutenant Governor. Deputy or subordinate elected or appointed to administer sub-duties of the region, or state under a division of powers. Definition of Crown. Sixth interpretation down. 1. Imperial or regal power sovereignty. The government under a constitutional monarchy. Monarch. Definition of Chancellor. The head of the government in some European countries, such as Germany. Just like Russia, USA does not go past 1952 in successfully establishing independent nations outside of King George VI. This is the extent of American and Russian understanding of crown customary law. OSCE, EU, UK, France, UN General Assembly, NATO, and the Commonwealth nations history, from unitary states to crown customary law as it really is. Unitarian countries are defined by a central government without regional, provincial, state or territorial division of powers. These countries are governed by a one-size-fits-all. This is a majority in the world today, 166 out of 193 nations. More than this is the crown customary law that takes the idea of federalism and tears it to shreds, as is witnessed in Canada, Australia, New Zealand, Iraq, India, Brazil, Sudan, Argentina, Venezuela, and Somalia to name a few. Crown customary law is found in over 8,000 references from OSCE, EU, UK, France, UN General Assembly, NATO, and the Commonwealth nations. Outside of Crown customary law, the unitary states have 10,000 references to abolishment of regions, and states under any division of powers, * more than this 54 nations, plus 31 have taken Crown customary law as a weapon against regionalism, and USA and Russia's defined federalism absent of Crown customary law, *. The OSCE demands members relinquish the death penalty. However, this is a direct violation of the UN Charter under the powers of a UNSCP5 member, *. The EU holds many unitary states and itself institutes a brand of federalism restricting any subdivision of powers for regions or territories. * more than this is the EU has Crown customary law at the epicenter of its UNSCP5 member France. * there are many EU states that are core Crown customary law embedded, constitutionally. *. UK and France were freed in World War II under the promise. The Atlantic Charter 1941 *. The end of colonialism *. The complete independence of colonies and overseas territories *. The UN Charter 1945 *. The end of Crown customary law in international law. Since 2021, UK has been allowed the new Atlantic Charter outside of educated Republicans, Democrats, House, Senate, the Russian Federation, or any of the UNSCP5, *, a clear violation of the UN Charter 1945, *, this gives the UK royal family an override over the UN Charter 1945, *. The Commonwealth nations are all based in Crown customary law, and are mostly unitary, with very few under federalism, *. This is contrary to the UN Charter 1945, and violates the institutions of Russia and USA entirely, *. The UN General Assembly is represented as a massive majority under unitary and Crown customary law UN states. Russia and USA have failed to implement federalism because of their differences in democratic vs. autocratic stances over implementing a division of powers. They have failed to see that without regionalism under a division of powers, the idea of human equality, diversity, religious, cultural, civil and political rights are completely gone for a vast amount of UN states and the many citizens within. * This education was never made available to any of the people throughout the world as promised in international binding law. * NATO, which once housed both Russia and USA, is now just USA and Germany as federalists and free from Crown customary law. Germany would be just one of 7 successful nations under Russian and American dismemberment and redesign since 1939 to 1952. The promise of independence, autonomy, sovereignty and regionalism through federalism. The UN Charter ending unitarianism and customary Crown law as it really is. Currently, a worldwide focus on Ethiopia is occurring over the mounting civil war. The federal government is going to war with the regions for city over regional government. Should the federal government win, rural Ethiopians will lose their land and division of power rights under federalism. The Tigrayan people will join the Egyptian and Sudanese people in the loss of farms and sustainable agriculture. Egypt, Sudan and Ethiopia all share a unique Spanish/UK colonial history, and with current Chinese and Italian investments there are going to be clear and present issues. The lack of human rights, social, economic, religious and civil rights across the world in many unitary and Crown customary law states is staggering. Africa, Southeast Asia, South America and parts of Europe continue uninterrupted. The common theme among the UN states is lack of education on international binding world laws both USA and Russia came to agreeable terms with. For decades both Russia and USA cleaned up the world by freeing many peoples and giving templates to see these countries, regions and territories succeed. When we analyze these countries, regions and territories we see time and time again regimes come back to once again make war, dictatorships and gross human rights violations become the all too common theme. Ukraine as it really is. Ukraine, like many Soviet nations, received its independence by raw means. The breakup of the Soviet Union was based on Mikhail Gorbachev's belief in regionalism. The underlying problem is the fact that international binding laws are not presently passed or approved by the Ukrainian government. Mikhail Gorbachev released many states, but without any tools for success. The majority like Ukraine became unitary, forced boundaries, and became mini Soviet unions themselves. Ukraine has watched its population go from 38 million to 26 million people in a span of 31 years. Ukraine voted for the Russian referendum and accepted the terms in majority. Months later, under Western influence of American President George H. Bush, Ukraine would go fully independent without respect for regional discrepancies inside Ukraine. When 11 million people flee a country, no one can make any inference that they enjoyed the new nation status. When we look at Ukraine's overwhelming economic indicators, we see corruption the very highest it has ever been. Asterisk it is 5 times higher than that of the Russian Federation. Asterisk there are no human rights in Ukraine currently. Asterisk Ukraine continues to operate undemocratically and violating their constitution continuously. Asterisk. In 2014 the regions of Donetsk and Luhansk Oblasts had an illegitimate referendum on independence from Ukraine. Asterisk a majority, 89% wanted independence. Asterisk. Ukraine is unitary, Russia and USA are federalist. Asterisk why would federalist states ever promise independence, but then constrict provinces, regions or territories to unitary forms of government that remove all sovereignty, autonomy and self-government? Asterisk. USA, UK, China and France all voted unanimously for the Russian Federation to take the UNSCP-5 seat, that was as it was under the former Soviet Union. Asterisk the decision by the Allies strips all UN states from forcing any will over the Russian Federation. Asterisk. Switzerland as it really is, an option for Russia and Ukraine. The oldest example of a federalist system is found with Switzerland. 13 confederated states to the 26 cantons today. Switzerland is arguably the oldest federalist nation in the world. Asterisk it seems clear that the many regions of the former USSR were not granted independence, forced into new boundaries, and moved from federalist to unitary systems. Asterisk when did a referendum to any of the people ever ask, would you like to be unitary, losing your autonomy, self-government and sovereignty, or remain federalist? Asterisk this is and was the truth of former USSR republics, regions and oblasts. Asterisk. To truly fix Russian and Ukrainian conflict a new question must be asked legitimately, and if Ukraine is incapable of doing the right thing then Russia, as the UNSCP-5 member is free to do what they need to do in binding international law. Asterisk after all it's been 31 years and nothing has changed for Ukraine. Asterisk. Customary crown law in federalist states, Canada, the path forward for Russia and USA as it really is. The country of Canada when viewed from outer space at the Arctic Ocean Center puts a perspective of federalism into view. Russia and USA border Canada, and we all hold the Arctic. At this point we share 9 groups of the Arctic First Peoples, Ninets, Khanty, Evenk, Chukchi, Aleut, Yupik and Inuit. 3. The Arctic Council, asterisk. All 3 nations have a clear history with the American Indian, the Canadian Indian and Métis. Russian America Company and the Hudson's Bay Company are logged into all 3 history books, asterisk. Russia and USA struggle with unitary systems because the world is a majority unitary and contrary to both countries. Since 1945, and throughout history, since you have passed many incredible world-binding laws. One of which is the shared view of ending colonialism. Colonialism is bound to crown customary law and continues in the UN state called Canada. No First Peoples of Russia or USA are suffering as much as they are in Canada. Often, Russia and USA trivialize the crown customary law used in Canada because Canada is stable. Asterisk. Canada's stability comes from its overabundance of resources for the small population and no other reason. This lucrative source of wealth comes at a great expense to the Canadian Indians, Métis, and Inuit, who are the same people from Russia and USA. Canada exploits and commits serious human rights violations that have been completely ended in the USA as of 1975. Asterisk Russia and USA are settled and ceded countries. This is not the same for Canada. Canada, like its federalist counterparts Australia and New Zealand, are crown customary law and far from settled. While USA and Russia accept the boundaries of these 3 colonies of the pre-1941 League of Nations UK and France, the actual land is much less. Currently, the near 40 million First Peoples and Canadian citizens are restricted to less than 11.34% of Canada. Our population density is much greater than reported to the UN. Customary crown law has divided these lands by class. First, second, third, and the savage/aboriginal/treaty Indian. This is the legal speak by the first class. All crown land, nearly 89% belongs solely to the first class whether elected or appointed. Asterisk. Russia and USA have both repeatedly shown great strength, grit, and determination in resolving broken crown customary law colonials as seen with South Africa. Asterisk. Canada needs constitutional dismemberment and redesign. This requires the unified Russian Federation and the United States of America to step in as the only federalist UNSCP-5 representatives. The longer you both wait, the stronger the crown customary and unitary states will get. Asterisk. A Canada through dismemberment of all crown can truly achieve a comparable status to Russia and USA. Asterisk the Russian/American Silk Road through the Arctic and an American Indian accessing historical settlements with the Canadian lands is what must be done. Settle the First Peoples for once and for all. Asterisk. The longer Russia and USA ignore the $12 trillion enemy, the worse it will be for the world. Asterisk. Conclusion by the author. This paper was written for Russia and USA specifically on the current state of affairs over Ukraine. The analysis and truth of unitary and crown customary law UN states was provided in great detail. It is my sincerest hope that Russia and USA take a step back to look inward at the legal speak. You both are in a bad place because you don't have a firm grasp of crown customary law or an acceptable narrative on unitary states. I didn't write this paper to slam the two institutions, but to strengthen them and return them to the victorious allies of World War II. Never again, the promise and basis of the United Nations.